Well, good afternoon. Mark Westcott here with Juanita Maiden, who'll be joining us any second now. Something just happened with her technology, but she'll be back in a sec. So today our topic is what happens when someone dies, and I wanted to go through that with Juanita to find out what it is that the process that people go through when someone in the family dies. What do we need to do to make sure that sorry, we're just having the technical problems here, but just want to make sure we know what happens and what. Hi, Juanita.
Hello, how are you?
We've been having technical problems, I know, but I was just explaining to the listeners, audience, that what happens when someone dies. There's a process involved. Most people probably won't be aware of the process, and I'm waiting with bated breath for you to explain what probate does and why it takes so long and what it means and why sometimes it's more complicated than other situations. But anyway, welcome.
Thank you. Hopefully you can hear me.
I can hear you absolutely perfect. Yeah, and the sun's not shining a lot in Brisbane by the look of it behind you.
No, it's a bit of a dreary day in Brisbane today. Hello, everyone. Good to see you again.
Absolutely. So, Juanita, you want to talk about what happens practically, and this is practically what happens from a estate planning point of view. When someone passes away, what are the procedures and so on that clients, customers, people need to do in regard to then sorting out the estate plan? What are the processes? It's obviously an area that's complicated and above my pay grade, so I'm handing over to you on this one.
Well, I think you highlighted a few questions there, and in some chats we've had before on this topic. But the very first thing that needs to be done is probably not process driven. So we'll often get a family member ring up and say, my parent or my family member has passed away. What do I do? Have you got the will? What's the paperwork? And the first thing I would always say to them is, the very first thing you need to do is take care of yourselves and take care of your family, and then look after the funeral and the burial wishes of the person that's passed away. So before you need to worry about anything else, that's the first step. The only reason why you may want or need a copy of the will at that point in time specifically is because sometimes people put in their will what their burial wishes are. So they might put in there whether they wish to be buried or cremated or not to be cremated, or if so, they might add wishes as to how they wish their ashes to be scattered or where they would like to be buried near another family member, etc. So that might be at that stage the only real reason why you need to or might want to inquire about a will or see its contents. So then I would just say, get everyone's affairs in order, make sure everyone's okay, look after the burial and the steps that need to be taken care. Then give us a call. So there's no immediate urgency or stress or rush in that regard.
Yeah, no, very good advice. The first thing is to take a deep breath. I remember when I was doing my flying training, when I was learning to fly, that my instructor kept saying to me, if you're up there and all of a sudden the engine stops or something happens and the radio breaks down or whatever it is that happens, he said the first thing you do is nothing. He said just gather yourself for a moment and so you get an understanding of what's going on. And I think that's important advice to people, is when someone passes away, really just be in the moment. Grieve, do what you need to do, and make sure you're safe and other members of the family are safe. And you're right, unless you don't know what the burial instructions are and all those sorts of things, and you need to talk to someone who's involved to work that out. Yeah, just take because you don't have to rush funerals or anything like that. You can take time. It's not like you'll do it tomorrow or whatever. So
that's right.
I think that was good advice.
And I guess practically too, we will often take that phone call, and what you need procedurally in that case is, first of all, identification, and ideally proof of death. Now, you won't have a death certificate by that point. Sometimes you may have a cause of death certificate, which is a form that's filled out by a doctor, or that's basically confirming a death has happened, but it's not the actual death certificate. So you might find your lawyer, if you're ringing up, will require your ID and ideally proof of death if they're not aware of that themselves, which often in small communities they will. And the reason for that is if it's not clear, is because we don't want to be releasing people's private information to those that aren't authorised to receive it. So we have seen, as in the legal profession, times where people are ringing up and pretending people have passed away to get that sort of information or a copy of the will. So we have to, as lawyers, have to make sure we respect the wishes of the client or the deceased person, and make sure that those sort of security questions are ticked off. So if you're asked for that, it's not a slight on yourself. It's a matter of, you know, protecting the client and the person who may have passed away, to make sure their information remains private or released to the right person.
So I would, it's funny what people think up, isn't it? I would have never thought that you'd ring up a lawyer and saying, you know, Fred's died. Can I have his will now?
Yeah.
Just to because you might be nosy in regard to what's in the will. Gee.
Yeah, absolutely.
Things, don't they?
Yeah. Probably from there, the next step is often not often, 99% of the time, the funeral director will be the person who helps you with the death certificate. So usually they will prepare the appropriate paperwork and with your assistance and send that off, and the death certificate will come back to them, and they will give that death certificate to the appropriate person. So if there's a will, the executor of the will, or the next of kin, etc. That is an important document because will basically be needed for a lot of the administration of the estate going forward, and usually certified copies will be required at some stage. So it's a one-page, a lot of people would have seen it, a one-page document which lists the deceased name, their spouse, their children, the cause of death, etc. And certainly your lawyer will be wanting a copy of that to assist in the administration going forward if they're engaged to do that.
Actually, you've raised a good point there, and it's a great delegation or outsourcing, isn't it? Is that the funeral directors? I mean, really, that's they do most of this stuff for you, don't they? Once you've chosen, I mean, if you know someone's going to die, you can sort of pre-arrange the conversation with funeral directors. If someone dies suddenly, same thing though. You know, you go and if you sort out the funeral director, their job, isn't it, is to not only speak to the hospital or whatever in regard to death certificates and so on. They can coordinate the cremation and so on, and with the church, the service, all those sorts of things. That's kind of the simple way out is, and I guess that's why you hire them, the funeral directors, to take care of a lot of those things for you. And that's really the first priority, isn't it? I mean, the will and all that sort of stuff. I mean, that's kind of afterwards, after the funeral's over and after everyone's kind of got through the emotional part of that, I guess, is when you start thinking about speaking to the lawyers, unless there's specific things you don't know. Because the truth is, most executives of estates will wait a certain period of time anyway, because you've got 6 months, haven't you, if someone's going to contest the will and all those sorts of things. So nothing needs to happen in a hurry, does it?
No, and you touched on lots of different things there that I love to talk about.
Okay.
Probably
I'll shut up with the rest now.
Probably the thing I will mention before we move on from the death certificate too is that that will normally take about 3-4 weeks, perhaps, till you actually get that. So it certainly doesn't happen overnight. And up until that stage, there's not a whole lot that can be done. With I guess the next step when you talk about the will, if there is a will, let's work on the basis that there is a will. Yeah, so a lot of people ask us, well, by a lot, some people still ask us these days, so when is the reading of the will? When's that going to happen? And that's just something that doesn't happen unless it's on a TV show, really. We don't have formal readings where everyone comes and we have a dramatic reading of the will and people gasping. So it just doesn't happen. There's only in my...
I'm just going to cut it. That is a really good point, isn't it? Because you see that in movies and so on, like, all the family are sitting around waiting for the reading of the will. What did I get? What did they get? Are we going to have a blue here in the lawyer's room? But I mean, that just doesn't happen, does it?
No.
Somebody dreamed that up for a movie once, and it sort of caught on.
Well, it can and it does happen, but it does not happen regularly. So I, in my career, have had one reading of a will, which is at the request of the family, where there was 5 or so adult children of the gentleman that passed away, and mum had already passed away, and I think 2 of those children were executors, and they just felt more comfortable if they could all be there together and we could walk them through the will rather than those 2, I guess, look to the others like they were trying to keep them out or anything. Or they just felt that would really assist them in that process, which we were happy to do. But it's certainly something that rarely happens.
Okay. So they saw it from the point of view you would do that if there was likely to be confusion, or if maybe 2 of the kids were executors and the other 3 weren't, and so on. So going in and having the lawyer read it and explain it takes the pressure off the 2 kids who might be the executors of the estates, of the estate, so that the other children could see that no one's trying to pull anything over their eyes. They're very clear in regard to what the intentions of mum or dad were, and so on. So
exactly. Yeah, that's right. So I guess then what happens once you're at that stage is we would normally talk to the executor of the will at this stage and explain to them what their role or duty is, which is in a real nutshell a 3-step process. So your executor needs to identify your assets, pay your liabilities, and then carry out your wishes that are set out in the will. And you may have heard me say before, I often say to our executors or to our people making wills that an executor can do everything themselves if they want to. They can do nothing themselves and get a solicitor to do it all for them, or somewhere in the middle. Some executors are happy to, say, deal with the bank, for example, but need help with a property transfer. So really it's a matter of the executor getting some guidance, usually from their solicitor, to explain what needs to be done, and what that will be will entirely depend on what assets and liabilities there are, and then making a decision as to what they can attend to themselves, or what they might need help with from a solicitor or an accountant or a stockbroker or financial planner, etc. So that's sort of the next step. Once you get a copy of that will, we would release a copy of the will to the executors on production of ID again. So make sure we're releasing it to the right person, and then assist them from there as they need. Okay.
A quick question. I hope you've answered all the thoughts I gave you before, but what if the cause of death, lost at sea? I remember my olden days, they used to use the example, if you were lost at sea, it was 5 years or 7 years before you could be officially classed as dead. What happens if someone goes missing and they can't find them? They're presumed dead. I mean, there's a little twist for you.
Yeah, there are.
You know the answer.
Yeah, you definitely need to take all possible measures to locate that person. This is the same for beneficiaries too, actually. Locate that person, or make due inquiries. At the end of the day, if you can't prove a person is dead, there is a length of time, and they actually is just escaped me at the moment, that there's a presumption of death, but you can also get a court order too. So for example, if there might be a tragic airplane accident where a lot of people, the plane is lost, so the body's never found. This is a really morbid conversation, isn't it? But it's reality. And so there's not an ability to prove date of death, etc. But it's in all likelihood that they have passed away. Then it's possible to get a court order basically verifying that presumption of death. So there are different procedures depending on the actual circumstance. But
so the plane that was lost. Well, a great example is the plane that was lost a few years ago. That
MH360.
Yeah, that went off radar and all those sorts of things. I mean, I mean, obviously, well, you think they're all dead, but they could have landed somewhere, and who knows?
Yeah, and that situation is different to the situation where someone's just gone missing with no explanation. So there's different legal principles and different procedures depending on the circumstance. One thing that it's not unusual to see is when a beneficiary can't be located. So in that case, that's a situation where you need to try to use every possible avenue to locate that beneficiary, and then if you can't, and you want to protect the executor against possible recourse down the track, you can obtain an order of the court, which allows the executor to go ahead and distribute on the basis that beneficiary may not be alive, or and therefore it can be distributed alternatively. So they're kind of quirky things that we don't see a lot, but there are ways. Yeah.
Yeah, I hadn't thought of that, but I mean, there would be times, wouldn't there, where somebody random has been nominated as a beneficiary and no one knows where they live or who they were, or where to track them down, even. So
especially if they've been estranged. Yeah. So you look at things like electoral rolls. You can look at court registries. Google can help sometimes. But
right.
Yeah, there are definitely ways you can do that. You spoke about timeframes too. So. And briefly mentioned 6 months, so I should probably explain the 6 and 9 month key dates. But look, how long does it take to administer an estate is one of those unfortunate how long is a piece of string questions, and it all depends on what's in the estate and how complex it is, and what the fact scenario is, the beneficiaries, etc. Look, you'd be looking at, and I'll explain in a minute why it's usually no less than 6 months, but it could be 12 months. So 6 to 12 months is probably a good guide for a usual estate.
Yep.
Everyone has heard of contesting wills, and I'm sure we've had some separate topics on that specifically. So if someone is going to contest a will, they have to give notice to the executor. And look, we're using the term executor today, but you can use that interchangeably with administrator if you haven't got a will, but they need to notify the executor within 6 months that they're going to contest the will. And once they've done that, the executor isn't allowed to distribute the estate until the 9 month period. Now, that person who is given notification they're going to contest the will within 6 months then have another 3 months to actually do it, which takes us to 9 months. So if the executor has got that notice within 6 months and then distributes anyway, then they're personally liable. So if you receive that notice, you have to wait until the 9 months. Then if that person has formally commenced an application to contest the will, which is filing documentation at the court and serving it on you, then basically everything stops as far as the administration goes, and that dispute is resolved, hopefully, or worked through. But if you don't get that notice by 6 months, and even if you do, and then there's no formal application made within 9 months, then you are able to distribute the estate per the will.
Okay, so if somebody doesn't stick their hand up within 6 months, it's over. They can't contest.
Well, there's always exceptions, but
in general.
They still can. But if you were to distribute after 6 months and then they later filed, you as an executor won't be personally liable as such.
Okay.
So it might depend on the circumstances. If you know that there is one looming, and you might want to take a little bit more of a cautious attitude, but generally notice within 6 months and then the formal application within 9 months.
Okay. Probate. It's one of these things that most people don't understand, including me. So could you explain what probate means and how that affects the process of distribution by the executors?
Yes. So a grant of probate is a document, and why is it needed? It's needed in situations where the assets are of a certain type or value. So when you have money in the bank over usually about, it depends these days, like 20, 30, 50,000, perhaps 20,000 for some banks. the bank will require you to get a grant of probate before they release the funds to you as executor. And the reason is because they want to ensure that you are the correct person to release the funds to. So it's a risk perspective. It's minimising the risk from them that they're releasing it to the wrong person, and that you have the relevant powers. Other times that you might need it is if you're dealing with shares. So the share broker might require a grant of probate. Superannuation trustees will often require a grant of probate before they deal with your released superannuation funds. Sometimes if there's litigation on foot, it might be desirable or necessary to obtain a grant of probate. So if you have an estate with really minimal assets, or assets of a low value, then often you'll find you don't need a grant of probate.
Okay.
So if you do need a grant of probate, what it entails is lodging paperwork at the court registry, and that's essentially a court form. It's an application. There's an affidavit the executors fill out, which exhibits, which means attached to it is the original death certificate and the original will. All that's lodged at the court registry, fee paid, and the court registry looks through all of that and basically makes a decision or considers, yes, everything is in order. This is the last will of the deceased. This person or people are the executors. We are going to grant the probate of this will. And it's literally a document that they give you with a seal, and that official document is the grant of probate. From there, you need to give copies of that to your bank, your share registry, your super trustee. They'll often want the certified copies of that before they deal with you or release funds. So that's the general process, and the reason why. Usually costs, unfortunately, an extra with registry fees that are payable to the court, plus legal fees to do all that process and assist. It's usually a few $1,000s all up. So unfortunately, it's that extra bit of expense, which comes out of the estate. But sometimes it's not needed, and if it's not needed, then great. Well, I guess less, a bit less process and a bit less cost and time. Time-wise, how long does it take? Look, usually you can pull that documentation together pretty quickly. It depends on how quickly a solicitor can turn that around for you, probably, and your ability to sign the documents. Once you have all the paperwork collated and signed and prepared and filed at the registry, normally it would take another few weeks, depending on how busy the registry are. Could be 2 weeks, could be 5 weeks, and that comes back to you. So really, you're looking at like a 6 to 8 week perhaps period from way to go as far as getting that grant of probate.
Yeah, you raised there's just something you said before that sort of triggered a thought, and that is the last will and testament. Someone lives in Perth. They've did a will over there years ago. They come over here for 6 months and they decide to change their will, and you do their will for them. They go back to Perth. So the most recent will is here in Brisbane. They go back to Perth if they were let in, and eventually they pass away over there, and the local solicitor thinks he's got the last will and testament. And how does anyone know? How do they track down? And I know you're going to tell me you advertise in the paper and all that sort of stuff, but if you have no idea and have lost contact with the client, he's back in another state, you've got the most recent will, but nobody knows about it. What happens? There's two questions, I guess, there. What happens? And two, is there any liability on the executors if 3 years later they go, whoops, here was the will which superseded the one we've worked off?
Yeah, a lot of people are really surprised there's no registry of will. So therein lies this tricky problem. And it's taken us almost the whole session, but the answer to this really is communication. So I would always tell the client to tell your executors where your will is. If no one knows, then no one knows. So, your solicitor may be, or your accountant, your professional advisors may know that information, and maybe you may be in a community or a situation where they will know if you've passed away. But if they don't, for example, in that example you gave, then it's really important that your family or your executors know where your will and documents are. So when someone does pass away, they know where to ring and get that information, because it can be really tricky. And I guess the way to protect the executor, which was one of your questions there, is that's when you do go through that advertising process. So as part of the grant of probate application, you need to advertise with the Queensland Law Reporter, notify the public trustee. You used to advertise in the paper, but you don't have to do that anymore. So those sort of parts of that process are basically trying to draw out any creditors or draw out any other wills. And if there isn't, then the executor who's issued the grant of probate can proceed, knowing that they won't have any recourse on them if they've done that in all good faith to administer the estate.
Yep. What happens though if there's totally different outcomes in the two different wills? The old will is used and distributed, and suddenly they find, whoops, that wasn't what they weren't supposed to get that money. That was supposed to go to a new relationship or a new partner or something like that. Too bad, or
no? There's recourse. So the correct beneficiaries that missed out, can follow a process of recourse of the money or the assets to where it went to the wrong beneficiaries.
So you can't
and
claim
potentially recoup it. But the problem there is, what if they've spent it, or what if it's disappeared? And so that is when there is potential recourse against the executor if they haven't followed due process and minimised, done everything to minimise that risk, I suppose. So that's where it's really important for executors to get that good advice and understand that, because those little pesky steps can sometimes protect them from a messy situation down the track. So there is potential recourse for the beneficiaries that missed out, but it doesn't mean practically that that's going to happen, unfortunately. So it depends on the situation.
Yeah, like you say, if they spend all the money, then it's too bad. But I mean, if there's assets involved, then the correct beneficiaries, the ultimate beneficiaries, can take action to.
Yes, there is action that can be taken. Yeah.
Okay, no, that's good. Okay, we've just got a couple of minutes left. Is there any time? Always just flies when we're chatting away. But anything?
Probably. Probably just one thing I'd mention is that we've spoken this whole session about wills and a grant of probate. What if there's no will? So it's a very similar process, except it's called a grant of letters of administration. So it's just a different type of grant. And where there's no will, obviously there's no one being named as executor. So someone has to take it upon themselves to make that application to the court, which is a very similar process. And there's a pecking order in the law about who has the first right to do that, and so on. So that's the same process, but it's a similar process, but a different type of application. Yeah.
That's if someone doesn't have a will. Now that raises a whole lot of issues too, and I mean, we haven't touched on yet things such as superannuation and so on. When someone dies, superannuation may go straight to a beneficiary or not if they've done binding death nominations and all those sorts of things. Assets in trusts and all those sorts of things need to be taken into account because they don't go through the will. So as we've talked about before, but I mean, the bottom line here, I think, is what you're saying is there's a process, and a very proper process for when someone dies. If they have a will, if they haven't got a will, there's another process that people need to go through. But also don't forget the outside things that like superannuation and benefits under a trust or control of trust or whatever.
And probably one even more important thing that we haven't mentioned is children. So a will, it gives you the opportunity to nominate guardians of your children if the parents have both passed away. So another reason why, which we didn't mention right at the start, that it might be important to have a look at that will sooner rather than later as to who the people are that the parents wished to be guardians of their children, because that's a really immediate need, isn't it? So along with any funeral wishes or burial wishes, that's also probably a reason why you might want to see that will in that circumstance sooner rather than later. Although having said that, it doesn't need to happen overnight. You can take a breath and, as I said, get the funeral arrangements in place and make sure the family's okay, and then look at what's been pointed out in the will in that respect.
And take a deep breath. Absolutely. No, but you're right. A whole range of things there. And once again, the key to all this is communication, which we haven't talked about so much today, but it's communication, but also having these conversations with your lawyer and your other professional advisors along the way to make sure that when something does happen to you, because it's not a matter of if, it's just a matter of when when something happens to you is that those around you, those that are important to you, know what your current wishes and legal documentation is, and that you make it as simple as possible for those who are left behind. And that might be a topic for another conversation, is some of the stuff that we do in regard to the human elements of estate planning. You know, it's all very well to have all this legal stuff taken care of, but things, you know, the human side of when someone dies, what needs to be said, or what instructions need to be left behind for the children and so on. Very important part as well.
Absolutely. Yep. Absolutely.
But anyway, thanks for your time today, and thanks for who's watching in. Juanita from Murdoch Lawyers in Brisbane. Certainly, if you ever need a second opinion, highly recommend Juanita to. If you know, if listening to us sometimes prompts you and has you thinking, well, I wonder if I've got all this. You know, they talk about all these things. I wonder if I've got all those taken care of. I can say, can't I, Juanita, that you're happy to give a second opinion on what people currently have. Have a look at your wills and your documentation at no charge. Just give you a sort of a brief opinion, and then if you need things fixed, we'll, you know, hopefully you'll take that through as well. So from Juanita and myself, thanks again everyone for watching in today. I hope that was useful in regard to what happens when someone dies and what you need to do to solve everything. Okay, thanks again, and we'll see you in a couple.
Thanks, everyone.
Bye.